The President, please be seated. The chamber is now back in session. The President, the International Co-Prosecutor, you may proceed.
Thank you, Mr. President. Very briefly, and I have not addressed this morning because I know the court has established a schedule for these hearings. We obviously listened with some interest to the representations made by the Defence Counsel for Nguyen Chia, and we have some concerns about some of the matters that were stated during that address, in particular, obviously, because these proceedings are public and matters are reported in the press, and we would like an opportunity later today, as the trial chamber sees fit, we don't want to interrupt the schedule of things this morning, to respond to what was stated, because we believe that there are some factual inaccuracies in what has been stated, and we think it's very important the public essentially has the entire picture. Thank you.
The President, thank you, International Co-Prosecutor, for your remark. Pat Persing, you may proceed. Pat Persing, thank you, Mr. President, for allowing me to stand. First of all, my respect to the bench. Due to the health of my client, I'd like to seek leave so that she can return to the detention center. She will remain so until the conclusion of the initial hearing due to her poor health. Thank you. The President, thank you, Counsel. For this request, with appropriate reasons, and also that is the right of the accused to participate or not in this hearing, the Chamber allows and grants the request. The Chamber instructs the security guard to bring Ms. Tiret back to the detention facility. Also, I'd like to instruct the ICT to link the audio-visual communication of this hearing, which has already been prepared for her to follow the proceedings. You may take the floor, says the President.
President, Your Honours, we have two requests for clarification in respect of the matter of witnesses, the discussion on Thursday. Our question is whether we are only discussing coming Thursday the witnesses mentioned in your list of tentative witnesses, or are we also discussing the witnesses which seem at this stage to have been denied by Your Honours? That is our first request for clarification. Our second request for clarification is the following. Could you please provide clarification as to why on Thursday we have to use pseudonyms for the witnesses that have been put on the list. We haven't quite understood the reasons for this decision. And in this stage, I might add that it is our position that at this point there seems to be no reason to use pseudonyms for the witnesses to be discussed on Thursday. So 2 requests for clarification.
President, thank you, Council, for your remark, which is rather important. The Chamber takes note of that and will advise the parties and, of course, yourself at the appropriate time. That is before the date on the discussion of the list of witnesses, experts, and civil parties. The President, after my discussion with Judge Cartwright, I'd like to respond to Nunji's counsel regarding your remark. As the Chamber has sufficiently indicated the reasons that when it is not the appropriate time for the identification of the witnesses, experts, or civil parties, in spite to the principle of the protective measures for those witnesses, experts, and civil parties, the Chamber has so far not received any report from the Victims and Witness Support Section regarding the status and the requirements as to whether which civil parties or the experts or witnesses require the protective measures and the extent to the harm. And the Chamber will consider that. For that reason, the Chamber will not allow the presentation of the identification names of those witnesses, civil parties, or experts on the tentative list. It has to be confidential at this stage. And we advised against it can only be done in public or open session only once all the parties agree to the use of the pseudonyms of those witnesses, experts, and all civil parties. So I hope this matter is now clear. And the Chamber has already worked on the pseudonyms in the tentative list. Mr. Salsavan, I noticed you want to raise any matter? Salsavan, thank you, Mr. President. Good morning, Your Honors. I'd like to make 2 observations briefly, so not to interrupt the proceedings. That is in response to the National and International Council in regards to the status of the victims. I congratulate those victims, and I think we should not confuse the role of the victims and the witnesses. Of course, we observe that there are more than 1 million victims, but there are only 3,800 plus represented by those 9 lawyers. Therefore, I'd like to emphasize that sitting in front of me, there are 9 lawyers representing more than 3,000 victims. And to my right, we have the international co-prosecutor and the national co-prosecutor, who are the main leaders in charging my client. And in my role as the defense counsel, I'd like to suggest that both the national and international co-prosecutors in their arguments in order to find justice for the general public my client, of course, wants to seek the truth as well, and he's not afraid of seeking the truth. And for the co-prosecutors, of course, you can charge my client of any crimes if they wish to do so. This chamber has already decided that on the killing or the genocide, of course, it's not committed by the head of state. It's like the former king. And it is alleged that my client is involved in the alleged acts. And point number 2, I'd like to seek the permission from the President and the bench that if my client is exhausted, because if you observe the rest of the accused are not present here, and only my client has a better health, and my client wants to also participate in ascertaining the truth. Who killed those people? My client seeks the permission to leave, but will return in order to cooperate fully with the chamber. And I hope the chamber will grant such a permission. The President, before the break, the chamber already advised you and the public clearly on the proceedings during this initial hearing to give the priority to those accused who have problems with health, who has advanced age, that they are allowed to leave the courtroom for a short break, for example, to use the bathroom without seeking permission from the chamber. And secondly, even if for them to stand, there is no need. When the judges enter or exit the courtroom, which is usually mandatory, that all the participants and the public are required to stand as a respect to the judges entering or exiting the courtroom, but we grant such a permission due to the advanced age and poor health of the accused. If you have any other matters which have not yet been raised, please do so firmly, objectively, rather than on what has been said already by the chamber. For example, any substantive issue on the list of witnesses, civil parties or experts that they deemed the appropriate issues to be raised, so that we can share the views and make the decision appropriately, accordingly, and that the list can be finalized by the end, by the conclusion of the hearing. ជាកិច្ចបន្តឈានចូលដល់របៀបបរិយាការទាញហេតុផលដែលផ្ទាល់មាត់តាក់ទងទៅនឹងអញ្ញត្តកម្មស្ដីពីគោលការណ៍
The President continues. Now we proceed to the oral argument on statutory limitations in relation to non-business indemnity. The Chamber will today commence oral argument in relation to a number of defense preliminary objections. The first for consideration is the preliminary objection concerning the principle of non-bis in idem, or the prohibition of multiple prosecutions in relation to the same offense. This preliminary objection has been raised by the Ieng Sari defense. The Ieng Sari defense has been allocated 1 hour for the presentation of this preliminary objection. The co-prosecutors then have 45 minutes in response, and the civil party lead co-lawyers 30 minutes. The Ieng Sari's defense then have 15 minutes in reply. The Chamber reminds the parties that it is familiar with all written pleadings filed to date and urges them not to merely repeat these in oral argument. We would like now to proceed to the defense counsels for Ieng Sari concerning the preliminary objection with regard to non-bis in idem.
សូមគោរពលោកចៅក្រមប្រធានសូមគោរពលោកស្រីចៅក្រមសមាជិក
Good morning, Mr. President, Your Honors. I am Ang Adam, and with me is Michael Kanawaz. We are honored and privileged to represent Mr. Ieng Sari. Over the next 3 days, we will be addressing certain preliminary objections we have to the jurisdiction of the chamber. Today, we will address the principle of nebis in idem and also the issue of Mr. Ieng Sari's royal pardon and amnesty. Tomorrow, we will address the statute of limitations for grave breaches of the Geneva Conventions and also the statute of limitations for national crimes. Our oral submissions on these issues will be brief, as we have clearly set out our position in our written submissions. We are mindful, however, that this is the first time these issues have been addressed an oral argument before this chamber and are therefore grateful for this opportunity. With your Honor's indulgence, we submit a brief summary which will be of assistance in following our presentation. With each preliminary objection, therefore, I will give a brief introduction to the issue and to each of our arguments. Mr. Canawas will follow up with further analysis and will answer any questions your Honours may have. I should also note that at this time we submit with all due respect that perhaps it would be more constructive and more efficient if any question you may wish to pose to us be done at the conclusion of each segment of our oral submissions. This aids the interpreters in not having to constantly switch between the parties to the proceedings. It also avoids the situation whereby a question is asked prematurely which would have been answered in the general course of the submissions. We trust that both the prosecution and the lawyers for the civil parties will also wish to take this approach in the interest of efficiency and in the desire to place all arguments in front of the bench. I would now like to proceed to the subject of the submission, our submission on nebis in idem. I will commence by introducing our arguments on the issue of nebis in idem, and my colleague, Canawas, will follow up with more detailed explanation of our argument and will address any questions your Honours may have. Under the principle of nebis in idem, a person cannot be tried again for the same conduct for which he was previously acquitted or convicted. Mr. Ieng Sari was already tried and convicted in absentia in August 1979 for having committed genocide in addition to several other crimes.
គាត់ត្រូវបានតុលាការកាត់ទោសប្រហារជីវិត
He was sentenced to death, and all of his property was
ហើយបង្គាប់ឲ្យ
ordered to be
រឹបអូរ
confiscated.
ទាំងអស់របស់គាត់ការយកលោកអៀងសារីមកកាត់ទោសសាជាថ្មីទៀតគឺរំ
It
លោភបំពាន
violates
លើគោលការ
the
ណ៍
principle
មិន
of
ជំនុំ
nebis
ជម្រះ
in
ទោស
idem
ពីរដង
enshrined
បទល្មើ
in
សតែមួយ
one
ដែលមានចែង
domestic
ក្នុង
Cambodian law,
ច្បាប់ជាតិរបស់កម្ពុជា
two,
កតិកា
the
សញ្ញាអន្តរ
international
ជាតិស្តីពី
covenant
សិទ្ធិពល
on
រដ្ឋ
civil and
និងសិទ្ធិ
political
នយោបាយ
rights, to which Cambodia is a party,
ប្រទេសកម្ពុជា
and
ជាភាគីមួយ
number three,
និង វិធាននីតិវិធី
procedural rules established at the international level to prosecute Mr. Ieng Sari at the ECCC.
អង្គជំរុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាយីសូមអនុញ្ញាតឲ្យយើងខ្ញុំ
Let us
ពិចារណា
consider each of
នីមួយ
these
មួយ
in turn.
ខាងលើនេះទី1ក្រមនីតិវិធីព្រហ្មទណ្ឌនៃព្រះរាជាណាច
The
ក្រ
Cambodian
កម្ពុជា
Criminal Procedure
មាត្រា
Code,
7 នៃក្រមនីតិវិធី
Article 7
ព្រហ្មទណ្ឌនៃ
of
ព្រះរា
the
ជាណាចក្រ
Cambodian
កម្ពុជា
Criminal Procedure
តម្
Code
រូវឲ្យបណ្ដឹងអាជ្ញា
requires
ត្រូវ
criminal actions to be
ហត់រលត់
extinguished
ខណៈដែល
where
បណ្ដឹង
they
នោះ
are
ស្ថិតក្នុងលក្ខខណ្ឌអាជ្ញា
judicata.
អុកជំនុំឬអាចនិ
or
យាយ
in
ម្យ៉ាងទៀត
other
ថា
words
ខណៈដែលបណ្ដឹងអាជ្ញា
where they
នោះ
have been finally settled
ត្រូវបានដោះស្រាយជាស្
by
ថាពររួចហើយ
judicial decision.
ដោយសេចក្តីសម្រេចរបស់តុលាការករណីរបស់លោកអៀងសារី
Mr. Ieng Sari's
អាជ្ញា
case
អស់
is,
ជំនុំ
of course, res
ការជំនុំ
judicata.
ជម្រះក្តីនៅពេលបច្ចុប្
The
បន្ននេះ
present trial
តាក់ទងនឹងអំ
deals
ពើ
with
ដែលត្រូវបាន
acts
ដោះស្រាយយ៉ាងច្បាស់
which
លា
have
ស់
been
រួចហើយ
definitely
ដោយ
settled
សេចក្តីសម្រេច
by
របស់តុលា
a
ការ
judicial decision
កាលពីឆ្នាំ
in
1979 ដូច្នេះមាត្រា7បានរៀប
Article
រៀង
7
ការកាត់ទោស
thus prevents
បច្ចុប្បន្ននេះ
the current
ប្រឆាំងនឹង
prosecution of Mr. Ieng Sari.
មាត្រា12នៃក្រមនីតិវិធីព្រហ្ម
Article
ទណ្ឌនៃព្រះ
12
រា
of
ជា
the
ណាចក្រ
Criminal
កម្ពុជា
Procedure Code
ចែងថា
states,
ដោយអនុវត្តតាមគោល
and
ការណ៍
applying
អាជ្ញា
the
អស់ជំនុ
principle
ំ
of res judicata,
ជនណាដែលត្រូវបាន
any
តុលា
person
ការ
who
សម្រេច
has been
ឲ្យ
finally
រួចខ្លួនជា
acquitted
ស្ថាពរ
by a
ហើយ
court order
ជននោះមិនអាចត្រូវ
cannot
បានចោទ
be
ប្រកាន់
accused
ទោសទៀតទេ
once again
ចំពោះ
for the
អំ
same
ពើដ
courses
ដែល
of
ទោះ
action,
បីជា
including
ក្រោម
the
ការកំ
case
ណត់
where such
បទល្មើ
action
ស
is
ថ្មី
subject
ផ្សេង
to
ក្តី
different legal
មា
qualification.
ត្រា12មិនបានកំណត់ពីអាជ្ញាអស់
Article
ជំនុំ
12 does
សម្រាប់
not
គោលបំណង
define
នៃ
res
មាត្រា
judicata for purposes
ឬ
of
ដាក់កំហិត
Article
ដល់ការអនុវត្ត
7 or
របស់វា
limit
ឡើយ
its application.
ផ្ទុយទៅវិញ
On
មា
the
ត្រានេះ
contrary,
ធានាថា
it
គោល
ensures
ការណ៍អាជ្ញាអស់ជំ
that
នុ
the
ំ
principle of
ត្រូវ
res
បានយកមកបកស្រាយ
judicata is read
ទូលំទូ
broadly
លាយដើម្បី
to
ដោតប្រព
encompass
ចូលនៅ
acquittals
ការកាត់ក្តី
and
ឲ្យរួច
situations
ខ្លួន
where an
និងក្តោប
accused
ស្រូបបញ្ចូល
is
នៅ
charged
ស្ថាន
with
ភា
the
ព
same
នានា
courses of action
ដែលជនជាប់ចោត
as in a
ត្រូវ
previous
បានចោទ
course,
ប្រកាន់ទោស
rather previous
ពីអំ
case.
ពើប្រព្រឹត្តដដែលដូចក្នុងករណីមុនដែរ
But such action
ប៉ុន្តែ
is
បណ្ដឹងចោទ
subject
ប្រកាន់បែបនេះ
to different
ស្ថិតក្រោម
legal
ការកំណត់បទ
qualification.
ល្មើសផ្សេងវាមិនចាំបាច់ដែលត្រូវបកស្រាយមាត្រា 12
It is not necessary to
នៅក្នុងករណីនេះ
interpret Article 12
ពី
in
ព្រោះ
this
ការ
case
ជំនុំជម្រះ
because
ក្តីលោកអៀងសារី
Mr. Ieng
នៅ
Sari's
ពេលបច្ចុប្បន្ននេះ ត្រូវបាន
present
Ham
trial
court
is prohibited
ដោយផ្អែកលើគោល
based
ការណ៍
on the broader
ទូលំទូលាយជានេះ
principle contained in
ដែល
Article
មាននៅក្នុងមា
7.
ត្រា 7 នៃក្រមនីតិវិធីព្រហ្មទណ្ឌ នៃព្រះរាជាណាចក្រកម្ពុជាលោកប្រធានលោកស្រីចៅ
Mr.
ក្រមជាទី
President,
គោរព
Your Honors,
ទោះបីជាអង្គជំ
even
នុំ
if
ជម្រះសា
the
លាដំ
trial
បូង
chamber
យល់ឃើញ
finds
ថា
it
វា
necessary
ចាំបាច់
to
ដែលត្រូវ
apply
អនុវត្តមា
Article
ត្រា
12
12
in conjunction
រួមជាមួយនឹង
with
មាត្រា
Article
7ក្តី
7,
ក៏មាត្រា
Article
12នេះចាំបាច់
must be
ត្រូវតែ
interpreted
បានបកស្រាយ
to apply to
ដើម្បីអនុ
those
វត្តចំពោះ
who
ជន
have
ណា
been
ដែលត្រូវ
finally
បានតុលាការ
convicted,
កាត់
as
ក្
well
តី
as
ឲ្យជាប់ទោស
those
ជាស្
who
ថាព
have
រ
been
ក៏ដូចជា
finally
ជនណាដែលត្រូវបាន
acquitted.
តុលាការសម្រេចឲ្យរួចខ្លួនជាស្ថាពរផងដែរព្រោះបានកំ
because
ណត់ត្រឹមតែ
limiting it
ជន
to
ណា
those
ដែលត្រូវបានតុលាការ
finally
សម្រេចឲ្យរួច
acquitted
ខ្លួនជាស្ថាពរនឹងនាំឲ្យមាន
lead
លទ្ធផលដែល
an
មិនសមហេតុផល
absurd result.
គោលបំណងនៃគោលការណ៍មិនជំរុំជំរះទោសពីរដង
The purpose of the Nibis-Nidam
ត្រូវ
principle
យកមកអនុវត្ត
applies
ដោយស្មើភាព
equally
គ្នា
in either
ទោះវាស្ថិត
case.
នៅក្នុងករណីណាក្តីក្នុងចំណោមនេះគោលការណ៍មិនជំនុំជម្រះទោស
The Nibis-Nidam principle is aimed
មានបំណង
at
ដើម្បី
protecting the
ការពារស្ថានភាព
finality of
នៃសាល
judgments.
ក្រមសម្រេចក្តីចុងក្រោយរបស់តុលាការនេះមានន័យថា
The idea is that
ប្រសិនណារឿងក្តី
once
មួយ
a case has
ត្រូវ
been
បានតុលា
dealt
ការ
with,
ដោះស្រាយចប់សពគ្រប់ហើយរឿងក្តីដ
it
ដែលនោះ
should not be
មិនត្រូវបើកសំណុំ
reopened,
រឿងសារឡើងវិញឡើយព្រោះវានឹងធ្វើ
as
ឲ្យ
this would seriously undermine
ការគោរព
respect
ដំណើរការនីតិ
for
វិធីតុ
judicial
លាការ
proceedings
និង
and
ប្រព័ន្ធ
the
តុលាការ
judiciary
ជាទូទៅ
in general.
តម្រូវការឲ្យ
The need for the
បំ
ECCC
ពេញកិច្ចជា
to
តុលា
act
ការគំរូ
as a model
សម្រាប់
court
កម្
for
ពុជា
Cambodia
ដោយកា
by
រប្រកាន់
adhering
ជាប់
to the
នៅ
rule
នី
of
តិ
law
វិធី
and the
គឺ
principle
សំទោ
of
សនៅនីតិរដ្ឋ
legality
គឺវិធាននៃច្បាប់និង
and
គោលការណ៍នីតិានុកូលភាព
increase
ហើយត្រូវបង្កើន
respect
ការគោរពចំពោះតុលាការ
for the judiciary and judicial
នីតិវិ
proceedings
ធីតាមផ្លូវតុលា
should
ការ
lead to
នោះ
or should lead
ការ
the
តម្រូវបែបនេះ
ECCC
នាំឲ្យ
to respect
អង្គជំនុំជម្រះ
and apply
វិសាមញ្ញ
the
ក្នុងតុលាការ
principle
កម្ពុជាត្រូវគោរព
of
និងគួរអនុវត្តគោលការណ៍មិន
Nibis
ជំនុំ
Nidam.
ជម្រះទោសពីរដងចំពោះបទល្មើសតែមួយគោលបំណងមួយទៀតនៃគោលការណ៍
Another
ជំនុំ
purpose
ជ
of
ម្រះ
the
ទោសពីរដងចំពោះបទល្មើស
Nibis-Nidam
តែមួយ
principle is
គឺដើម្បីការពាររារាំងបុគ្គល
an individual
កុំ
from
ឲ្យទទួលរង
undergoing
នៅភាពលំ
the
បាកធុញថប់
psychological,
តានតឹងផ្លូវចិត្ត
emotional,
ខាងអារម្មណ៍
physical,
ចំពោះរាង
and
កាយនិងផ្នែក
monetary
កាយវិការ
stress
ដែលរួមពាក់
associated
ព័ន្ធនឹង
with
ការ
a
ជំនុំជម្រះ
criminal
ក្តីពីរដង
prosecution
នោះ
twice.
គោលការណ៍នេះមិនតម្រូវតែអនុ
This
វត្ត
purpose
នៅ
does
ពេល
not
ដែល
only
ជន
apply
ជាប់
when
ចោ
an
ទត្រូវបាន
accused
តុលាការ
has been
កាត់ឲ្យរួចខ្លួនប៉ុណ្ណោះទេ
acquitted.
ភាពថប់អារម្មណ៍
The
និងភាព
anxiety
ធុញទ្រាន់
and
ដែលបង្
stress
កឡើង
caused by
ដោយការ
repeated
កាត់ទោសច្រំដែល
prosecutions
ប៉ះ
affect
ពាល់ដល់គ្រួសារ
families,
សាក្សី
witnesses,
និងសូម្បីដល់ជន
and
រ
even
ងគ្រោះថែមទៀតផង
victims.
ហើយវាទំនង
And
ជានឹងធ្វើឲ្យ
is
មាន
likely to be
ភាពធ្ងន់ធ្ងរឡើងថែមទៀត
exacerbated by
ដោយសារចំណាប់អារម្មណ៍ពី
media
ប្រព័ន្ធ
attention.
ផ្សព្វផ្សាយគោលបំណងនៃគោល
These purposes
គោលបំណង
of
ទាំងនេះ
the
នៃគោលបំណង
Nibis-Nidam
មិនជំនះទោសពីរ
principle
ដងចំពោះបទល្មើសតែមួយ
demonstrate
បង្ហាញថា
that it would be
វានឹងមិនសម
absurd
ហេតុសមផលឡើយ
to
ដែល
limit
ត្រូវកំណត់
the Nibis-Nidam
គោល
protection
ការណ៍
afforded by the Criminal Procedure Code of Cambodia to only those who have been finally acquitted.
រួចខ្លួនជាស្ថាពរបន្ទាប់មកសូមអនុញ្ញាតឲ្យយើងខ្ញុំពិចារណាពីកតិកាសញ្ញាអន្តរជាតិស្ដីពីសិទ្ធិ
International Covenant
និងសិទ្ធិនយោបាយ
on Civil and Political Rights or
មាត្រា
ICCPR.
14.7 នៃកតិកា
Article
សញ្ញាអន្តរជាតិស្ដីពីសិទ្ធិពលរដ្ឋ
of the
និងសិទ្ធិនយោបាយចែងថា
ICCPR states
គ្មានជនណាម្នាក់ត្រូវ
no
យក
one
មក
shall
ចោទ
be
ប្រកាន់
liable to be
ឬ
tried
យកមកផ្ដន់ទាទោ
or
សសារ
punished
ជាថ្មីឡើយ
again for an
ចំពោះបទ
offense
ល្មើស
for
ដែល
which
បានផ្ដន់ទាទោស
he
ជា
has
ស្ថាពរ
already been finally
ឬ
convicted
បានលើកលែង
or
ទោស
acquitted
ដោយស្រប
in accordance with
និង
the law
នីតិវិ
and
ធីព្រហ្មទណ្ឌ
penal
របស់
procedure
រដ្ឋ
of
នីមួយៗ
each country.
ហើយមាត្រានេះអាចអនុវត្តបាននៅអង្គជំនុំ
This
ជម្រះ
article is
វិសាមញ្ញ
applicable at
ក្នុងតុ
the
លាការកម្ពុជាយើង
ECCC
និងរារាំង
and
ការកាត់
bars
ទោស
Mr. Ieng
នៅពេល
Sari's
បច្ចុប្បន្ននេះ
present
ប្រឆាំងនឹងលោក
prosecution
អៀងសេរីពីព្រោះកម្ពុជាជាភាគី
because
មួយ
Cambodia is a party to the
កតិកាអនុសញ្ញានេះ ហើយ
ICCPR
រដ្ឋធម្មនុញ្ញ
and
របស់
its
កម្ពុជា
constitution
ប្រគល់អាណត្តិឲ្យកម្ពុជា
mandates
គោរព
that it respect
កតិកាសញ្ញា
covenants
និងអនុ
and
សញ្ញានានា
conventions related to human rights
សិទ្ធិមនុស្ស
to which Cambodia is a
ដែលក្នុងនោះ
party.
កម្ពុជាគឺជារដ្ឋភាគីជួនកាលមានបញ្ហាមួយចំនួន
There are sometimes
ដែល
issues
អនុវត្តបទបញ្ញត្តិនេះ
applying this provision
នៅពេលដែលតុ
when
លា
a
ការ
court
នៃរដ្ឋ
of
មួយ
one state
ត្រូវ
is
បានស្នើ
asked
សុំ
to
ឲ្យទទួល
recognize
ស្គាល់
a previous
សារ
judgment
ក្រម
of
ពី
a
មុន
court in
របស់តុលាការ
another
ក្នុងរដ្ឋមួយ
state.
ផ្សេងទៀតពេលខ្លះ
it is sometimes
គេយល់
held
ឃើញថា
that
បទ
this
បញ្ញត្តិនេះ
provision
មិន
does
ត្រូវអ
not
នុវត្តក្នុង
apply
ស្ថានភាព
in
បែបនេះឡើយ
such situations.
យ៉ាងណាក្តី
However,
ក៏ស្ថានភាពបែបនេះ
such a
មិនកើត
situation
មាននៅ
does
ក្នុង
not
ករណីនេះ
exist
ឡើយ
in this case.
ការជំនុំជម្រះក្តីកាលពីឆ្នាំ
The 1979 trial was held
ត្រូវបានប្រ
in
ព្រឹត្តឡើង
Cambodia
នៅក្នុងប្រទេសកម្ពុជា
by a Cambodian court,
ដោយតុលាការកម្
and
ពុជា
the
ហើយ
ECCC
អង្គជំនុំជម្
is
រះ
also
វិសាមញ្ញក្នុងតុលាការកម្ពុជា
a Cambodian
ក៏
court.
ជាតុលាការកម្ពុជាដែរអបតក
The
មិន
ECCC
ដូចតុ
is
លាការ
unlike
ចំពោះកិច្ច
the ad hoc
ដតី
tribunals
ទៀតដែលមិន
which
ត្រូវ
are
កំណ
not
ត់អាណត្តិ
mandated
ឲ្យគោ
to
រពកតិកា
respect
សញ្ញា
the
អន្តរជាតិស្ដីពីសិ
ICCPR.
ទ្ធិពលរដ្ឋនិងសិទ្ធិនយោបាយឡើយនៅទីបញ្ចប់សូមអនុញ្ញាតឲ្យខ្ញុំបាទ
Finally,
ប្រស័យពីវិ
let
ធាន
me
នីតិវិ
address
ធី
procedural rules
ដែលបានបង្កើតឡើងនៅកម្រិត
established
អន្តរ
at the
ជាតិ
international level.
គេត្រូវការលើកយកប្រធាននីតិវិធី
Procedural rules established at the
ដែល
international
បង្កើតឡើង
level
នៅ
only
កម្រិត
need
អ
to
ន្តរ
be
ជាតិ
considered
មកពិ
if
ចារណា
existing
តែ
procedures
លើកណា
do not deal
នីតិ
with
វិធី
a
ដែលមាន
particular
ស្រាប់
matter,
មិនអាចដោះស្រាយ
or
បាននៅ
if
បញ្
there is
ហា
uncertainty regarding their interpretation or
ឬតែលើក
application,
ណា
or if there is
បើ
a
មាន
question
ភាពមិនច្បាស់លាស់
regarding
តាក់ទងនឹងការបកស្រាយឬការអនុវត្ត
their
ឬប្រសិនណាមានចំណោទ
consistency
បញ្ហាមួយ
with
តាក់ទងនឹងភាពស៊ីសង្វាក់
international
គ្នា
standards.
ជាមួយនឹងបទដ្ឋានអន្តរជាតិតែប៉ុណ្ណោះនេះមិនមែនជាករណីចោទ
This is
នៅក្នុង
not
ស្
the
ថានភាព
case
ប
in
ច្ចុ
the
ប្បន្ននេះឡើយ
present situation.
ក្រមនីតិវិធីព្រហ្មទណ្ឌនៃ
The
ព្រះរា
Criminal
ជាណាចក្រ
Procedure
កម្ពុជា
Code of Cambodia and the
សញ្ញាអន្តរជាតិស្ដី
ICCPR
ពីសិទ្ធិពលរដ្ឋ
adequately deal with the matter, and there is no uncertainty concerning the interpretation or application.
ទាំងក្រមនីតិវិធីព្រហ្មទណ្ឌ
Both the procedure code of Cambodia and the ICCPR are clear and applicable. Nonetheless, should the trial chamber determine that it must consider procedural rules established at the international level, it should follow the guidance of the ICC statute. Since it was ratified by a large number of state parties and is more representative of international consensus than the states of other criminal tribunals. The ICC statute contains a nebis in idem provision which would prohibit the current prosecution of Mr. Yangsari. In conclusion, that the Criminal Procedure Code of Cambodia, the ICCPR, and consideration of international procedural rules all require that the ECCC terminate Mr. Yangsari's current prosecution and find that it does not have the jurisdiction to try him for the crimes charged on the basis of nebis in idem. That concludes my submission, and my colleague, Mr. Kanawas, who also represents Yangsari, will be adding further on this. I am very grateful, Your Honors and Mr. President, for your attentive listening to my observation.
Good morning, Mr. President. Good morning, Your Honors. And good morning again to everyone in and around the courtroom. I'll try to be brief and try not to repeat the arguments that were made either by my colleague or the arguments that we believe are rather comprehensively set out in our numerous submissions concerning these issues. The trial chamber requested that we address two particular matters in our supplementals. One was the pretrial chamber's decision itself, and then the other was to consider whether the 1979 trial that was provided by the People's Revolutionary Tribunal was conducted in conformity with basic fair trial standards, including the legal framework upon which it was based. And I think that it might be better to address the second question first before I go to the first one, dealing with the pretrial chamber's overall decision. So was the 1979 trial a proper trial, at least based on the legal framework upon which it was existed? Would anybody among us in this courtroom want to be tried in that fashion? I think the answer to that question is a resoundingly no. Was it perfect? No. Did it follow the procedure that was set at the time? Yes. More importantly, and I think this is the issue that needs to be addressed, and I respectfully submit has not been raised before, is if Mr. Ieng Sary had been detained and incarcerated, would he have been given the death sentence? Would have been executed? And the answer to that is yes. And that's the proof in the pudding as to whether that judgment would have been considered proper and final. The prosecution, nor the pretrial chamber, nor the United Nations before Mr. Ieng Sary had appeared to after the issuance of the judgment, none of them came out and said that that trial was a sham trial and that the sentence itself could not and would not be carried out if Mr. Ieng Sary had been detained up until the time he was granted the royal decree pardon and amnesty. Now, granted, the Constitution had changed, where the death penalty was done away, but the fact remains that even if he had been arrested after the change of the Constitution, the death penalty would have resulted in a life imprisonment sentence. So while the trial may have had its limitations based on what we would consider a fair trial, especially a fair trial for ourselves, I mean, if you compare it, for instance, with the trial that Saddam Hussein received, certainly it was a better trial. Saddam Hussein's trial was not a fair one by any stretch of the imagination. It did not meet international standards. He nonetheless was executed. You may say he had a final judgment because it summarily went up to the Court of Appeals. The point being is, if you are judging that particular trial based on what the law was at the time and the system that was available at the time, then the answer to that question is it would have been a proper trial because the sentence would have been carried out. And that is why, and we'll get to this in our next argument, when Mr. Ieng Sary negotiated with the government having approached Mr. Ieng Sary concerning an amnesty and a pardon, was made very clear that the 1979 conviction and judgment would be set aside and not carried out. So I believe I have nothing further to add to that unless there's something from the bench. I understand that the prosecution has argued, well, that wasn't a final judgment because they didn't have a second instance court to review it, and also it could not have been final because he was tried in absentia. Fact is, the Lebanese tribunal, for instance, provides for trials in absentia. The then system provided trials in absentia, and even currently today, I dare say, in Cambodia, trials in absentia can be carried out, and it is not mandatory. It is not mandatory, based on the current rules of procedure, that a retrial be held. Not to mention the fact that it would be up to the accused to determine whether he or she wished to have a retrial. So now I understand that the prosecution in their brief have pointed out certain articles in the criminal procedure. We respectfully submit that you look at Articles 365 and 368 and Articles 489 and 493 as well. because we believe that the prosecution erred in pointing out what can or cannot be done under the criminal procedure, the current one. Needless to say, the current criminal procedure did not exist at the time. And again, we've briefed this issue comprehensively, so I'll move on to the next issue, unless there are questions from the bench. Seeing no questions, I'll move on to the next issue. And here, my argument may seem a little disjointed. It won't flow as well as my colleagues, because I just want to touch upon some matters that were not touched upon by my colleague. And I'm going to try to restrict my comments to matters that were brought up by the prosecution in their response. So in other words, my remarks will be more in line of a reply. Thus you will have our reply to what was raised by the prosecution, and they of course will then have an opportunity to respond to us in like kind. With respect to Nebuchadnezzar, since there's no need for me to go into the specifics as to what it is, what its purpose, its intended purpose is, the prosecution, their entire argument, essentially, if I may speak for them, or paraphrase them, rests on the fact that they look at Article 12 as opposed to Article 7. And they argue, and I believe this is in paragraph 11 of their response to our supplement, that under Article 12, that article defines what in fact is res judicata, in that sets out the parameters, in a sense, of Article 7. We, of course, have argued that Article 12 simply expands upon Article 7. And so we would submit that when you do the analysis, to look at both of them together, although as indicated by Mr. Angodom, we rely primarily on Article 7 and simply submit that you need not go to Article 12. But be that as it may, the prosecution we submit is incorrect when it states that we have accepted that Article 12 defines Article 7 simply because we did not explicitly argue that. You will find that in paragraph 11 of their response, where they make this bold assertion. The prosecution wrongly asserts that the position that Article 12 defines Article 7, and that this in fact has been the position, the accepted position, by the pretrial chamber. And the prosecution cites paragraph 120 of the pretrial chamber's decision on our appeal against the closing order in support of this proposition. So they rely on paragraph 120 in support of this assertion. Now, this paragraph quotes Article 12, but it makes no findings as to the relationship with Article 7. And in fact, this is what the pretrial chamber stated. I'll keep it brief. It states Article 12 of the CPC, as set out above at paragraph 45, may be regarded as an example of the application of the doctrine of res judicata. As an example, there lies the difference. And we highlight this because we believe here the prosecution has mischaracterized, or has not accurately, I should say, characterized the position taken by the pretrial chamber. I don't wish to turn this into a personal attack. All of us see things differently at times, but in this instance, I believe they simply get it wrong. Then the prosecution asserts in paragraph 13 of its response that Article 7 cannot be considered on its own because it is insufficiently specific, and that the trial chamber must therefore look to international principles. We submit that this is also incorrect. While the Cambodian Code of Criminal Procedure does not define res judicata, this does not mean that the term is insufficiently specific. And we also submit that res judicata has a commonly accepted legal definition, full stop. But even if the prosecution is correct, even assuming that they are correct, that the trial chamber should look to international principles to determine the meaning of res judicata, this does not translate into looking at procedural rules established at the international level concerning nebis in idem. Res judicata is a general principle of law. So while you may look what others or how others have defined it, we submit that looking at procedural rules is not the definitive translation. And of course, how did Cambodia function before, the judiciary function before the ECCC, where they have a term like res judicata in it? Clearly the judges, the prosecutors, the lawyers would have known what it meant, and clearly they would have known how to apply it. They didn't need the establishment of this institution to come to a conclusion that they must look at other international institutions and to look at other procedural principles to define it and to define its applicability, even with respect to this particular case, which we all acknowledge has crimes which have been characterized as international in nature. Now, the pretrial chamber, if I may make some observations there. The pretrial chamber, in paragraph 122 of its decision on our appeal, found that Article 12 would not apply to prior convictions, since Article 12 uses the word finally acquitted, and expanding the scope of Article 12 to include convicted persons would conflict with other provisions of the Cambodian Criminal Code, Criminal Procedure, which allow proceedings to be reopened in case of convictions. So here the pretrial chamber focuses on these two words, finally acquitted. So somebody has to be finally acquitted in order for res judicata to kick in a sense. That's what they're saying. Then the pretrial chamber goes on to state in paragraph 123 of its decision, and here I'll quote a little bit, it says, expanding the scope of Article 12 to include convicted persons would conflict with other provisions of the Cambodian Code of Criminal Procedure, which allow proceedings to be reopened in cases of convictions. In particular, the Cambodian Code of Criminal Procedure provides for the possibilities to, one, review the proceedings in case of conviction, and two, for a person convicted in absentia to make opposition to the judgment and to be tried again. And it further goes on to say, applying Article 12 to convictions would rule out these two possibilities of reopening the proceedings as pursuant to Article 5, we presume they mean 7, Article 5 of the Cambodian Code of Criminal Procedure. The criminal charges could no longer be pursued or would have to be terminated. As I've indicated before, the purpose for nebis in idem is for the accused to avail himself or herself to that particular protection. It is thus consistent with other provisions of the Cambodian Code of the Criminal Procedure, which act to protect the interests of the accused. And in this instance, we're submitting that Mr. Ing Sari should not be tried twice for the same crimes when the first time he was convicted, and that conviction was final at the then existing procedure that was in place in the laws, and the court that had been duly constituted and was fully capable of not only carrying out the trial but also carrying out the sentence itself. The government would have carried it out. Now, my colleague has discussed briefly a little bit about the International Covenant on Civil and Political Rights. I don't want to go into a lengthy expose on that. I think we all fully understand that. We know that it does apply because it's explicitly set out, as was noted. It's implicitly set out in the Constitution, explicitly for the ECCC. And the pretrial chamber determined, however, that Article 14.7 of the International Covenant on Civil and Political Rights was inapplicable because this article has no, quote, transnational application, unquote, but only to an internal domestic effect. So first time in the proceedings, as I'm aware of, we have this term transnational application, not international, but transnational. Now, how they came up with that, there's no real explanation. There's no guidance as to why they see this as a transnational application. We do submit that in this instance, the pretrial chamber got it wrong. There are no issues of transnational application relevant to this matter. Absolutely none. And I believe we have set it out in our submissions, and so I won't repeat our arguments. But simply to say that in the 1979 trial occurred in a Cambodian court, and just as the present case is being conducted in a Cambodian court. Which brings me to my next issue, and I can address it now, or we can address it at some other point during the next 2 or 3 days, or I can simply make a few comments and rest on what we have filed in our copious submissions throughout the last 2 or 3 years concerning this particular issue, and that is whether the ECCC is a national court or an international court, or whether it is this hybrid, or it is something in between, this internationalized court, something which, with all due respect, I don't think that such a thing exists, especially here at the ECCC, because all they're doing, all the Cambodian government is doing, is accepting assistance, financial as well as personal assistance in the trial of these cases. And even though this particular institution availed itself and is responsible for trying international crimes, it does not make it an internationalized. So unless I'm prepared to go forward on that, but I would prefer that we deal with this at some other point. Suffice it to say, it is our respectful submission that the ECCC is a national court. That's how it was designed. That's what the government of Cambodia agreed to. That's what was agreed to by the United Nations. There are copious quotes everywhere concerning the nature of this particular tribunal, and we submit that simply to make it into some sort of an internationalized, or come up with a catchy phrase saying it's internationalized for the purposes of then disregarding some rather important legal issues such as the royal pardon and amnesty in order to get around that particular block to this particular case is inappropriate. I just have a few more remarks, Your Honors, and then I'll sit down. I just want to wrap up by saying, again, the prosecution's argument, they rest their case primarily concerning the previous trial, that it was not conducted according to law, to law, and that the judgment was not final, and that it was in absentia, and of course there was no second instance. Now, I think I'm not going to lecture to the trial bench as far as the second instance. We all know when finally Cambodia came up with a second instance court. But let's assume for the sake of argument that you need a second instance court in order for those judgments to be final. Is a suggestion then being made that every single judgment that was conducted on trials conducted from 1979 in the national context, from 1979 into the time that Cambodia finally had a functioning second or third instance court where you could finalize the judgments. Are we saying that all those cases were not final? That all those individuals that were convicted did not fully enjoy their rights? That there has been this gross miscarriage of justice for all those cases? And that any one of those individuals at this point in time can raise the issue that they have not been availed of all their rights? Because that's the implication. We submit at the time it did not have a functioning second instance because it wasn't meant to have a second instance. That was a final judgment. And that final judgment could have been executed the moment that Mr. Ingsari would have been captured. I don't believe I have anything further to add, Your Honors. I am prepared to answer any questions if there are any questions from the bench. Otherwise, I would make one request, and that is, if we have not taken the full time, the full 1 hour allotted to us for our opening remarks, if it would be possible to have that time tagged on towards the end for us to use in the event it's necessary. I don't believe it will be necessary, but if we do need it, if we could use any time that we haven't used in this with our opening remarks concerning this particular issue. Thank you, Your Honors, for your attention.
The President. Thank you, Counsel, for your oral submission concerning the preliminary objection with regard to the nebis in idem principle. It is now appropriate time for lunch adjournment. The chamber will take the adjournment for lunch until 1:30. The session will resume by 1:30. All parties are invited to return to the courtroom before 1:30. The security guards are now advised to bring Mr. Kilsampon and Insari to the holding cell, and that you are instructed to bring them back to the courtroom before 1:30. Thank you.